welcome to this discussion on electoral bonds conducted by ADR. Today is February 23rd, 2024, and it's exactly 8 days since the landmark judgment on electoral bonds. In these 8 days, we've had several hundred media articles and TV shows covering this event, and social media has also been buzzing with activity. Even the Prime Minister has commented on this judgment. At the same time, we keep getting requests and calls from voters saying that they have some basic questions about what is an electoral bond, why were they scrapped, and how can black money be controlled? Are things going to get better or worse after the Supreme Court judgment, etc.? And why is money important in elections? Why do we need to regulate it? So we will discuss all these issues and more. So first, a brief introduction about our panelists today. You can all see Professor Jagdeep Chhokar. He's a former dean and director in charge of IIM Ahmedabad. He's a co-founder and trustee of ADR. I will tell you a lesson one fact about him. He is an internationally known scholar and was the editor of a set of books on cross-cultural studies with top scholars from around the world. And in his 50s, out of his sheer interest for the work that we do in ADR, he went and actually attended classes and completed a law degree. So thank you, Jagdeep, for doing that. Our other speaker is Major General Anil Verma. He heads ADR. He's a highly qualified person. He is a BCom and an MSc in Defense Studies and an MA in Political Science. He had 37 years of distinguished service in the army, where he saw many interesting things while serving the nation. Currently, he is the head of ADR since 2013, and he oversees all operational administrative activities at an all-India level. He continues to serve the nation even after retirement from the army. Lesser known fact about him, in a school leaving exam, he was an all-India rank holder. So welcome, Anil, for this discussion.
Thank you.
And we have Shivani Kapoor, who is program lead and manager at ADR. She is a highly qualified lawyer. She has an LLB and also an LLM. And she's registered with the Bar Council of India. And she specializes in many things, including contract law, intellectual property rights, right to information, constitutional rights, electoral and political issues, participative democracy, transparency, and so on. She has been with ADR for more than 10 years, and she has been active in drafting and pursuing the petitions, various petitions of ADR. A lesser known fact, it is none other than Shivani who drafted the ADR petition on electoral bonds, which has captured the attention of the nation. Thank you so much, Shivani, for being with us.
Thank you, sir.
Well, I am Trilochan Sastry, and I am the founder and chairman of ADR. So let's get straight to the topic. I will request Professor Jagdeep Chhokar to tell us what are electoral bonds. I think you're muted, Jagdeep.
Yeah. Thank you, Trilochan.
Yeah.
Electoral bonds are, I guess, a formal description would be that they are a form of financial instruments which were invented by the government of India in 2017. The then finance minister had 2 paragraphs in the budget speech titled Transparency in Electoral Funding. In the first paragraph, he said that, for the last 70 years, we have not had any progress in making electoral funding transparent. And in the second paragraph, he introduced electoral bonds. And since the title was Transparency in Electoral Funding, everybody thought this is a very wonderful thing. But the very same afternoon, he had a media interaction in which he said, and I quote, electoral bonds will be in the nature of bearer bonds the identity of the donor will be anonymous. End of quote. Since that day, I have been personally trying to look for a dictionary which tells me that transparency and anonymity are synonyms of each other, which means that they are the same thing. So electoral bonds are an instrument, or I should say they were an instrument because they no longer exist, which claimed they would provide transparency, but actually they provided total opacity. Whatever fig leaf of transparency was there in electoral funding till 2017, that was removed by electoral bonds. So electoral bonds were a very dangerous, insidious instrument. The biggest problem with the electoral bond was that any company, whether profit-making or loss-making, could donate any amount of money, regardless of even if it made huge losses, it could still donate huge amounts of money to any political party. And bulk of these donations, of course, went to the ruling party.
We will discuss all this thread by. So thank you for that description. Any citizen of India, when electoral bonds were available, could go pay something like 1,000 or 10,000 rupees to State Bank of India at designated branches and get an electoral bond. The bank would note down the details of who you were, and the bearer bond, that is the electoral bond, would not have your name, so you could anonymously donate it to a political party. The idea was that political parties also should not know who is a donor. And after that, within 15 days, the political party had to present that electoral bond back in the State Bank of India and encash it. And the State Bank would, of course, note down the details of who was encashing it and the number of the electoral bonds, etc. So technically, both the buyer of the electoral bond and the one who encashed it, the names and details would be known to the State Bank of India, but not known, as Jagdeep has said, to the public at large. So, Anilji, I request you to tell us what are the reasons that the government gave for introducing these electoral bonds.
Okay, thank you, Professor Sastry. Professor Chhokar has already covered these actually in his introductory remarks with three basic things which the then Finance Minister, late Shri Arun Jaitley, said in the Parliament and otherwise, was firstly that since independence, not enough has been done as regards political party funding goes. There are a lot of lacunas, so it needs improvement. And second thing he said was that we want to introduce transparency into the political funding system because the whole scheme will be through payment through the banks and KYC, etc. would have been done. And the third major ingredient was that they wanted to protect the identity of the donor for fear of retribution from the other political parties. So these were the main reasons which they gave, and Professor Chhokar has elaborated them. I would also just add that electoral bonds were available in the denominations of 1,000 rupees, 10,000 rupees, 1 lakh rupees, 10 lakhs, and 1 crore rupees. And any corporate person, company, or any individual, or any HUF, that is Hindu Undivided Family firm, anybody could buy these from State Bank of India only. A window used to open for about 10 to 15 days, depending on the government's orders, once in a quarter, or generally before the elections are held, whether they were state elections or the general elections. So since the time this scheme was introduced in January 2018, a total of rupees 16,530 crore rupees worth of electoral bonds have been sold and purchased. Another aspect is that the electoral bonds which are not encashed, they are supposed to go to the Prime Minister's Relief Fund. Okay, now I just want to give the reasoning which the government gave while the court was hearing the case, the Supreme Court.
Ask Shivani to tell us that, if you don't mind. So Shivani,
Yeah.
You see, there was one more reason the government added. That is that it will also remove black money. That is transparency, black money, donor privacy, etc., etc. substantial improvement over the existing system. So Shivani, my question to you is that since the government's reasons, at least on paper, are very laudable, without discussing whether those reasons were right or wrong, we'll do that later. Why did the petitioners challenge this electoral bond?
Because the basic essence of Electoral Bond Scheme and basically the Finance Act 2017 that introduced Electoral Bond Scheme and corporate funding, unlimited and anonymous corporate funding, the main essence of these things was anonymity and unlimited money. So where a system where the whole source of funding which is going to the political parties is anonymous, and the money which corporates can give, which is unlimited, I mean, how can we say that that is a very transparent and accountable system? Already there were so
I think some network issue. Okay, Professor Sastry, may I continue?
Shivani, like to repeat.
Shivani's, I think, okay,
I'm
hello.
not audible.
Yeah, now you're okay.
Yeah.
Yeah, please carry.
So I was saying was already there were so many problems with the existing laws. Political parties were already not furnishing information that they were supposed to give. There have been instances where Election Commission had continuously sent reminder letters to them to furnish their financial statements in time. BSP is on record, had said that they have not received donation above 20,000. They have always received a donation below 20,000 for the past more than 10 years. So this was the kind of system we were already dealing with. Now, on top of that, when you introduce something which just has anonymity, opacity, and unlimited flow of money, how can we say that that system is completely accountable? So that was the main reason why we challenged this scheme.
So much. Just for the record, listeners may want to know that there were three petitioners. One was ADR, then there was another NGO called the Common Cause, and the third was the Communist Party of India. And just for the record, these three petitioners have nothing to do with each other, and ADR has nothing to do with any political party. The procedure is that when similar petitions are filed before the court, the registrar or the court decides to club them and hear them together, and all the three petitioners are put together. Other than that, we have no actually here.
Professor Sastry, before you jump to the next question, can I just complete the arguments which the government gave?
Please,
Because
please.
that is important for the viewers to know.
Correct.
When the hearings were held in the Supreme Court, the reasoning given by the government council was that firstly, this would be an improvement on the prior legal framework, which was mostly cash-based and incentivized infusion of black money into the political party system. Second reason they gave was that donors to political parties apprehended retribution from the political parties. Hence, electoral bonds will maintain confidentiality of the donor and incentivize them to contribute clean money to political parties. Third was that it would ensure balance between the clean money into the system as against the right to information of the system. Now, donor of public companies had to have, they had to declare the amount contributed in their books of accounts without disclosing the name of the political party. State has the obligation to, this is what the council said, that the state has the obligation to safeguard the privacy of its citizens, including right to their political affiliation. This is with reference to the buyers of the electoral bonds. Next point, he says that maintenance of anonymity of political donations is part of the concept of secret ballot. So they are equating it with secret ballot because it enables a person to make a political choice without fear of victimization or retaliation. And lastly, the point which he said was that amendments to the RBI Act, the Representation of People Act, and the Income Tax Act were intended to curb the cash donations and secure anonymity of the donors. Section 182 of the Companies Act, which removed the limit of 7.5%, was intended to disincentivize the creation of shell companies. Now, these are the reasonings which the government gave in the court.
Thank you so much. We'll come to how the Supreme Court argued it because it gets a little technical. But before we lose track, I want to tell one of you to tell us, maybe Shivani, tell us very clearly what is the Supreme Court order?
Supreme Court gave order on two bases. One was whether the
Actionable item. What is the order?
The order is that now the SBI has to furnish all the information, all the electoral bonds given to political parties till date, with the name of the political parties, with the name of the persons who have donated to political parties, and the amount to the they have to give that information to the Election Commission of India by 6th of March, and Election Commission of India has to furnish those details on their website by 13th of March. So
Thank
this
you.
is what they have to do.
Can SBI
And
continue?
electoral bonds and unlimited anonymous corporate funding are held unconstitutional, which means now that is not allowed at all.
So they cannot give any electoral bonds in the future.
Yes.
Now, we'll get into the legal issues because, Anil Verma has told us the government reasoning, and the Supreme Court has gone into great legal length to tell us why and what are the constitutional legal issues. But before we get technical, I would want us to tell voters or inform voters why is maybe Jagdeep or Anil can tell us why is electoral funding important in the first place, and why is transparency in electoral funding equally important?
You see, electoral funding is at the very heart of the system of elections. And elections are in turn at the heart of democracy. Democracy is operationalized through elections. And if money spent by political parties and candidates in the elections is completely anonymous, nobody knows where political parties get their money from, how will the voters decide whether a particular action or a decision taken by the government of the day has been taken in the national interest, or the people's interest, or in the interest of the company or whoever has given that political party money? So this phrase quid pro quo, which also finds very prominent mention in the judgment, that whether it is the money which is resulting in governmental actions, or whether it is people's welfare that is resulting in government actions. This is at the heart of political funding, and therefore this transparency is absolutely essential. Where political party may say we will do X, Y, Z, but when they actually do something, very often they just found that they are doing it because maybe a year down the road or 2 years down the road, a large company will make huge profits by that decision, and people actually may suffer by that decision. So this relationship between governmental and political party actions and money is at the heart of the entire political process, actually in the whole world. But in India, with electoral bonds, it had become completely out of control. And that is why we went to the Supreme Court, and that is why the Supreme Court upheld this.
Thank you so much. And before we get into the legal system, I have one more question. What were the events that triggered the introduction of electoral bonds? I'm just speculating that on one side, the Central Information Commission had made political parties as completely transparent under the Right to Information Act. On the other side, the Election Commission itself had tweaked the rules for electoral trust, which existed earlier, that they have to be more transparent. So this drive towards transparency, which continued from around 2006, 10, and continued for several years, did it have anything to do with the introduction of electoral bonds? What is your opinion? Anybody? Because it did, there was no need for introducing it unless there was some issue at stake.
The issue primarily was that all political parties are absolutely scared of revealing their sources of funding. Even when we first got the copies of income tax returns of political parties, it was discovered that the 80% of their funding was from anonymous sources. And we had been trying to figure out these sources of funding since the very beginning. That is how we also went to the Central Information Commission, and the Central Information Commission in a full bench anonymous judgment said that 6 national political parties are public authorities under RTI and they should respond to all such questions. They refused to do that. So political parties as a whole were feeling the pressure of having to become transparent about their political funding. And obviously the party which was getting the maximum amount of money was feeling most insecure. And that is what, in my humble opinion, led to the emergence of this electoral bond scheme, that with one stroke of pen, everything became anonymous.
Thank you.
Another, there was,
Yeah,
I also feel there was one more reason, maybe or may not be, but that was when Delhi High Court had found Congress and BJP guilty of taking foreign funding, and then when they changed the FCR, and then when they filed the petition basically against the Delhi High Court's judgment, and then they realized that our judgment was based on the FCRA 1978 and not the FCRA 2010, and then they tried to, and they brought the amendment to the 2000 Act, and then retrospectively they brought the amendment to 1978 Act. So I think all of these things kind of made political parties and the government realize that this source of money which is in the public domain, maybe that is harmful for them, and they should be bringing some sort of more anonymity into their funding mechanism.
thank you, Shivani. In short, for an ordinary listener who does not know law, what you're saying is that there was a High Court order against the BJP and the Congress, and it had forced them to become more transparent about foreign funding,
Yes.
prevent that knowledge from coming out. That was another trigger for introducing this committee. Anilji, you have any thoughts on why both of Jagdeep and Shivani have told us? Do you have anything to add to that?
No, I think the primary reason was to hide the identity of the donors because they feared victimization. And the amount which has been received by Electoral Bond Scheme, if you compare it with the semi-transparent Electoral Trust Scheme, which we will discuss later, the amount within these 4-5 years is many folds what used to come as political donations via the electoral trusts. So it is, I mean, it stands to reason as to why people were, not donating through the banks and all earlier. Is the moment this anonymity clause came, more money started coming to the parties.
Thank you. So in brief, what we have discussed so far is that what are electoral bonds, what did the government say about why they were introduced, and what did the petitioners say, which was opposite to the government, and the fact that the Supreme Court has struck it down as unconstitutional. So
Prof. Sastry, if I may just add a couple of things to what Shivani had said about the judgment. One was that we had filed, our main mudda was that, this is violative of Article 19(1)(a) and Article 14 of the Constitution. And when the court heard the thing and gave the verdict, the conclusions which it drew was that this amendments which the government had done to the RPA, the Companies Act, etc., was violative of the Article 19(1) alpha.
So
And the second,
see, we are going to get into full legal technical details, but just hold on for a minute because voters may not listen to us for the entire 1 hour. So I'm just getting the simple facts which an ordinary voter would like to know. Then we will discuss threadbare all the legal issues a little beyond. So before the electoral bonds also, there was political funding. So what was the earlier system? Did that earlier system stop or did it continue in parallel with the electoral bonds?
So the earlier system continued, it was not stopped. If I were to just give a very brief history for the benefit of the viewers or those who are not so well acquainted with it, the earlier system, till the earlier 70s was that private donations, membership dues, corporate funding, subscriptions, etc., were being done. then the 1964 Santhanam Committee and the Vanchu Committee report of 1971 highlighted the influence of illicit funding on political decision making. So in 1968, Indira Gandhi, she was the Prime Minister then, she banned corporate donations. In 1979, then government gave this thing that the political parties will be exempt from income tax if they file their annual returns and their audited accounts, the list of donors and donations more than 10,000 rupees. So this came into effect. Then after that, the thing was that
The limit was enhanced from.
yeah, then in 1980 to 1990s, the Companies Act was again amended and it allowed corporate donations, but maximum 5% of the average of 3 years profit of the company, which had to be approved by the board of directors. And disclosure was required in the profit and loss account and audited annual reports. Then in September 2003, the NDA government made companies and individual donations fully tax deductible, and they raised the threshold of the disclosure to 20,000 rupees, which meant
And
that
also
below,
it came to 7.5%, from 5% to 7.5%.
Hanji, that was also increased to 7.5%. And then in 2013 January, the UPA government introduced the Electoral Trust Scheme under Section 25 of the Companies Act. Now, the Electoral Trust allow corporates to donate without directly engaging with the political party, but they get income tax exemption. So details of the companies which are donating to Electoral Trust is disclosed. The Election Commission also issued guidelines on June 2014, which were approved by the CBDT, the Central Board of Direct Taxes, to submit annual reports of the contributions received and distributed to political parties to enhance transparency. There were some electoral trusts which were existing even before January 2013. At the moment, there are 18 electoral trusts which are registered with the CBDT. Now, public doesn't know the percentage of collections distributed by the electoral trust to the political parties. So only the ECI knows. We don't know. They put out a report in which all donations to electoral trust above 20,000, the details are there, who has donated, but we do not know what formula they apply, how do they distribute it to the political parties.
Thank you. So,
So this continues. So this system is continuing. Along
Yes.
with the normal donations to the political parties, whether in small amounts by cash or, cash remit, I must mention, it was reduced from 20,000 to 2,000.
Thank you.
So,
So
yeah.
the Supreme Court, judgment said three things. One is a 100% transparent system, which is for all check donations and online donations directly made either by individuals or corporations to political parties, which is still allowed. Number two, semi-transparent system, which is through the electoral trust, which is different from the electoral bond. Under the electoral trust, we know how much money a company has given to an electoral trust for political donations, but we do not know how much of it went to a political party. And on the other hand, the political party would tell us how much funds they got from the electoral trust. So the Supreme Court called it a semi-transparent system. And the third system, which was in operation until recently, was the electoral bond system, which was completely opaque, as several of our panelists have already mentioned. So thank you. So we have all these three systems running in parallel. So, this other public thing that we are hearing is about black money, that somehow electoral fund bonds would remove black money. So I would like to hear from all of you, what did the court say about electoral bonds removing black money? Anybody? So
Professor Chhokar,
I think he's on mute.
mute.
General Verma, please go ahead.
Okay, let me jump in for a minute. So the Supreme Court went into this question of black money, and they said that the main argument of the government is that because electoral bonds are through the bank and through the electronic system and through check, etc., they are more transparent, and therefore, if they are more transparent, it will reduce the incentive to give cash and black money. However, the court argued correctly, in our opinion, that the other two existing systems of electoral trusts and direct donations through check already existed. So, to remove black money, those systems were already there. So, the additional requirement of an electoral bond was not there, and it would have not been in any way to removing of black money. The other fundamental question that they went into, which I would like those of you who have read the judgment carefully to tell us, maybe all of you, the donor's right to privacy. In public, what they have been saying is that if the donor's name is known publicly, then the donor will be harassed, and therefore he should not be harassed, and he has a right to privacy. And on the other hand, the petitioners have been saying that the voters have a right to information. So how did the court argue out this issue of right to privacy of donor versus the right to information of the voter? What were the constitutional issues? Can you throw some light on that?
You see, the right of donors or privacy of their information was weighed against the right of the voters to know about the sources of funding so that they can exercise their right to vote, which is now a fundamental right. Now, in order to exercise this fundamental right to vote, voters need information about where do political parties and candidates get their money from. This right to information of the voters, as compared to the right to information of the donors who are making donations to political parties, were weighed, and the Supreme Court held that the right to information of the voters overwhelms the right to secrecy of information of the donors. And the court was unambiguous on this, that right to information of donation is secondary, but the right of information of the voters is primary.
Thank you so much. And one more thing before we get really legal, because we do want to get into the legal issues. So we have seen that the electoral bonds neither were instrumental in removing black money, and the need for donor privacy was also struck down by the court. So in essence, the electoral bonds were not adding anything to the flaws in the system. So one of the things that people have been saying in the media again and again is that we are going to regress back into the old bad system of cash and black money now that electoral bonds have been struck down. Any views on this from our panel here?
Well, I would like to say here that there has been a lot of hue and cry that with the stoppage of electoral bonds, the future of democracy in this country is doomed. I have actually written a piece somewhere earlier, a few months earlier, that there was life before electoral bonds and there will be life after electoral bonds. Indian democracy existed without electoral bonds for 65, 70 years. And Indian democracy was lauded all over the world as a very vibrant democracy. We know that it was not a very clear and a very good democracy, but it was still functioning very well, reasonably well, let me say. The electoral bonds, instead of making the functioning of electoral democracy better, made it infinitely worse, that it became totally controlled by money. And totally controlled by money, the color of the money and the source of that money was not known to any citizen, whether it was from company A, company B, company C, whether it was from foreign companies or it was from drug money or arms export money from foreign countries. Electoral bonds were a very serious danger to Indian democracy. and I am grateful to the court that they removed it. Indian democracy will function with the existing three mechanisms of political and electoral funding. We can certainly and we must improve those systems, but electoral bonds was not the answer by any stretch of imagination.
Thank you so much. So, Anilji, the basic question that we hear from the media people is that after striking down of electoral bonds, the amount of black money coming into elections is actually now going to increase, and we are going to go back to a very bad old system. What is your view on that?
My view is that firstly, prior to the introduction of the scheme, when the comments were asked, the Election Commission of India, the Reserve Bank of India, everybody was against the scheme. And they gave reasons. They said that this will, enhance the number of shell companies. It will be a process for converting black money into white. And even with the removal of all the amendment of the Companies Act, the RBI Act, the RPA, etc. All restrictions which were there earlier were removed by the Electoral Bond Scheme. So, in the hearings of the court and in the judgment also, if you read it carefully, the court has demolished this argument that it will if the electoral bond system is scrapped, then black money and cash. My answer to all these people who are saying this is, firstly, the cash was not reduced even after the demonetization scheme. Even now, when the electoral bond scheme is going on for the last 4-5 years, elections which have been taking place to the state assemblies, hasn't the ECI or others or these agencies, ED, etc., they've discovered mountains of cash in politicians' houses. So the question of that it has reduced doesn't hold water. The second thing is that even while the scheme was on, the seizures by the Election Commission of India prior to the elections during the canvassing period has gone up 4 times this last assembly elections that took place. So where is the justification that the cash had reduced or because of the electoral bond scheme? So what Professor Chhokar said, that it was continuing earlier also. So, and the court has also said that we need to devise better ways which are less restrictive to improve the system and reduce the black money and the cash.
So what you're saying in effect is that there was black money earlier, there was black money during the electoral bonds, and there will continue to be black money. We need to address it, but do it differently. So I will now get into.
So let me just add one thing. Black money is not only affecting the elections.
Correct.
Black money is affecting the entire country.
Correct.
I mean, you cannot remove black money from the elections and let it flourish everywhere else.
Yeah, so thank you so much. So now I'm going to go back a little bit more to Shivani because we're going to get into the legal issues in some detail. So just for the viewers, the Electoral Bond Scheme involved the amendment to 4 laws: the Representation of People Act, the Companies Act, the RBI Act, and the Income Tax Act. 4 acts were amended just to introduce this electoral bond scheme. And the method of introducing this was very interesting. It was done through the Finance Act 2017, under which there is something called a money bill. And this was passed in the Lok Sabha and did not have to be passed in the Rajya Sabha because a money bill does not have to be passed in the Rajya Sabha. And whether something is a money bill or not, as of now, the Speaker of the House is the sole person who will decide whether something is a money bill or not. So Shivani, with that background, can you tell us what is a money bill? What is a Finance Act?
Basically, Money bill is a bill which is basically under Article 110 of the Constitution. Money bill is basically a bill which is concerned with expenditure, income, and other financial matters of the government. And money bill is basically where Rajya Sabha has no say at all. So it will go to Rajya Sabha after Lok Sabha, but then but Rajya Sabha cannot say no about money bill. So Rajya Sabha cannot reject a money bill. So even if Rajya Sabha has any reservation regarding money bill, they still cannot do anything about it, and Lok Sabha will eventually pass it. So that is what is money bill. It has to do only with the expenditure, income, and other financial matters of the government. It has nothing to do with policy matters or other laws or regulations or anything like that. So that is basically a money bill.
I think thank you for explaining it so well. What is the reason, if you can tell us, or anyone can tell us, why this was introduced as a money bill? Why this electoral bond scheme was introduced through a money bill? Because it has nothing to do with money. They could have asked these 4 amendments to be passed directly in the Rajya Sabha also, and then it would have become a law. Why did they have to do it through the finance bill?
No, it was done through the finance bill for the reason that if these had been introduced in the Lok Sabha or Rajya Sabha, the government did not have a majority in the Rajya Sabha. As normal amendments, they would have been rejected by the Rajya Sabha. In the money bill, as Shivani very correctly said, the money bill does go to the Rajya Sabha, but Rajya Sabha cannot do anything to the bill. All it can do is to make suggestions for the Lok Sabha to consider. And very often, more often than not, Rajya Sabha does not pay, Lok Sabha does not pay attention to those suggestions. So practically, Rajya Sabha does not really have anything to do with the money bill. The other problem here was that the money bill, as Shivani said, has to do with income and expenditure, etc. A defining requirement for a money bill is that it must deal with something going into or coming out of the consolidated fund of India, which requires that is the fund from which all expenditure of the government is done. The electoral bonds were to be purchased by a company or an individual from the State Bank of India and were to be given to a political party. There is nothing at all to do with the consolidated fund of India. So electoral bonds, by no stretch of imagination, can be considered to be anything to do with with being a money bill, which was patently unconstitutional. And if I may add here, although it perhaps would have come up later, there are 3 or 4 other such issues where the government has misused the money bill requirement to pass laws which were not appropriate to be passed therein. And we had also challenged this money bill provision, but the Supreme Court said that since it is there in 3 other cases, and there is a 7-bench judge of the Supreme Court which is considering the money bill issue, this issue of the electoral bonds will also be considered there. And there is a possibility that even at that judgment, the electoral bonds will be struck down again on that count.
So thank you so much. Thank you. So this was part of the political strategy of somehow trying to get this one. One important thing that voters need to know is that before this electoral bond scheme was introduced, the government, in its wisdom, asked formally for the opinion of the Reserve Bank of India and the Election Commission of India on what are their views on the electoral bond scheme. And the court has quoted verbatim the responses of the Reserve Bank of India and the Election Commission of India. Would someone like to throw light on first on what the Reserve Bank of India said about the electoral bond before it was introduced in writing? So just to remind our viewers, the RBI Act says that only the Reserve Bank of India has the right to introduce what is called a promissory note or a bearer bond. That means rupee notes, currency can only be issued by the Reserve Bank of India or by the central government if authorized by the RBI under the RBI. So therefore, the Reserve Bank of India, in response to the electoral bond, said that this is threatening the sovereignty of the nation. It will bring into question the financial health of the nation, because these electoral bonds are going to be introduced neither by the RBI nor the central government, but by a scheduled bank authorized by the central government. So this is diluting the powers of the Reserve Bank of India, and therefore this should not be done. And the Reserve Bank also went on record to say that the existing, you can have electoral bonds, but just make it transparent and let it be online, then that will be fine. It will not be then be a promissory note. So the Reserve Bank has gone on record going against the Electoral Bond Scheme. Of course, the government ignored it completely. The Election Commission was also asked, and the Election Commission said exactly what somebody has said earlier, that the problem is that you can set up shell companies and divert black money, and the possibility of black money also increasing. And they also said that in the RP Act, Representation of People Act, there is a provision for barring. You cannot take foreign funds, or you cannot take funds from government departments or public sector units. And with this opacity of electoral bonds, the Election Commission will not be able to find out if that law has been broken. Therefore, we do not want electoral bonds. So two constitutional authorities, the Election Commission of India and the RBI, officially went on record, wrote to the finance ministry in the government saying that we do not want these electoral bonds. The government continued to ignore it. I think this is an important fact that we need to know. And I want to add in my personal capacity that the RBI is a very sacred institution of this country. It maintains the banking system, it maintains the financial health of the system, it looks at our foreign exchange, and so on and so forth. And constitutionally around the world, the RBI is a constitutionally independent authority and not subservient to the government of the day around the world. And such a constitutional authority, which is the sovereign guardian or custodian of the financial health of the nation, its autonomy and sovereignty was being attacked under the Electoral Bond Scheme. Some things are sacred and should be perhaps left alone. Now, coming back to the legal issues.
So let me add here.
Yes.
The file notings on the files of Finance Ministry have shown, which have been obtained under the RTI Act, that when the RBI continued to oppose, the Finance Ministry actually gave this reason, which is on record in the files, that the budget documents have already been printed. Therefore, no change can be made.
Wonderful, wonderful.
Such absolutely baseless arguments are available on record.
Thank you so much.
And both the authorities have called this electoral bond scheme and corporate funding as a regressive step. On record, they have said that it's a regressive step.
So the government ignored these two constitutional authorities, the Election Commission and the RBI, and went ahead. So let us inform voters about these four amendments. So we can start first with the RP Act, the Representation of People Act. What was the amendment that the government introduced?
So there were 4 amendments brought by this Finance Act 2070 to about RPA. So under RPA, the provision was that donation above 20,000 and above 20,000. So every single information was to be given by political parties in their financial statements. That was to be submitted to the Election Commission of India, and that is how people used to get know about who is funding to which political party. So 20,000 and above 20,000. So that was so through electoral bonds. If you get money through electoral bonds, political parties were not supposed to give any information about which political donor gave funded to which political party, what was the amount, name of the donors. So that was gone. So that was the amendment. So if you get money through electoral bonds, whether it is 20,000, about 20,000, or whatever money it is, so you are not supposed to furnish that information. So that was one amendment.
What was the amendment of the Income Tax Act?
So Income Tax Act, so political parties get exempted under Income Tax Act. There is 100% exemption given to the political parties. So, but the basic criteria for getting that exemption is that you have to give the whole audited statements to the Election Commission of India. Now, if you get money through electoral bonds, so that you are not supposed to give any information. So that was basically the sense of the amendment under Income Tax Act. So a third amendment was amendment to the Companies Law. Now, before the Electoral Bond Scheme and the Finance Act 2017, under Companies Law, political parties and the companies were supposed to give information in their statements about the amount of money given to them and the name of the parties, name of the companies which donated to political parties, both companies and political parties. And there was a limit to the donation, which was 77.5% of the aggregate 3 years of net profit. So that limit was taken away, the names, anonymity, that was added. So a complete black hole of the information, even under Companies Law. So that was number third amendment. And number fourth amendment was, like we discussed earlier already, we have discussed that amendment to the RBI Act, which means that, now RBI is not the sole authority to issue the promissory note. The government of the day can any day authorize any scheduled bank and they can issue the promissory note, and which was very scary, I would say. So these were the 4 amendments.
So thank you so much, Shivani, for explaining to us what were the 4 amendments. And we have already discussed that this was introduced to the Finance Act and so on and so forth. There are a couple of more questions which go beyond the legal one, which is looking forward. So the Electoral Bond Scheme is put down. Everybody knows that. And we have discussed at length all the legal and other issues for black money, right to donors, privacy, this, that, and the other, and how the law was amended were discussed. But the basic fact remains that we are back to status quo. And while the status quo is certainly better than electoral bonds, it still has many flaws, particularly the issue of black money, which many people are worried about. So what is your view, any one of us or all of you, how do we tackle this issue of black money and greater transparency in elections? And even the electoral trusts, although more transparent than electoral bonds, only partially transparent. So how do we attack this issue of black money? Because people around the country are concerned about it. Yeah, please go ahead. All of us can speak on this, yes.
So it is not very difficult to achieve this, to basically eradicate the issue of black money. It is in fact very easy, given that there is courage and will in the political class to do that. I mean, in fact, the issue of curbing black money was given, recommendations were given by the Law Commission back in 1999 in its 170th report. The latest bit, the 255th Law Commission report, which was issued in 2015. But if you'll see the amount of time which has already gone by, and not even a single recommendation has been made into law.
Can you tell us at least one of those recommendations?
So the recommendation is that every single penny should be there in the public domain, but nothing has been done so far. There should be limit to the election expenditure of political parties, but nothing has been done so far. The political parties should be brought under the ambit of RTI Act. Well, political parties have already rejected that order of the CIC. That there should be a CAG audit of the political party accounts, but it is not there. There is CAG audit of the NGOs. Every organization you think of, there is audit of that, but barring political parties. Then there should be a law, comprehensive law dealing with political parties. We have laws for schools, temples, colleges, any institution you name, we have a law for that. But when it comes to political parties, there is not a single law dealing with political parties. There is no way you can penalize the office bearers of political parties. There is no way you can penalize a political party if they contravene any law. There is no way to do that. The maximum Election Commission can do is issue reminders, maybe issue show cause notice. But beyond that, what do we do? So these are all the issues. These are the issues which can act, and if they are dealt with, if proper laws are in place, if legislature bring those kind of laws, then I think black money can be curbed. But then they are not doing so because, well, we know that why. So
Shivani, this is very brilliant what you just said. I would request that you secretly prepare a one-pager note on all the suggestions that have come from the earlier law commissions on removing black money, and we will put it out in the media, because we need to inform the public Because
if I may add,
yes,
there is perhaps, what Shivani has said is a very, very outstanding summary of what needs to be done for kind of large scale political reforms.
correct.
If we confine ourselves to electoral and political funding, there is a very simple solution which goes back to when we had demonetization in the country. When the demonetization was reduced, it was said that we should move towards a digital economy and all payments should be done through digital means. As a matter of fact, we were also told that if we want to pay 10 rupees to a cycle rickshaw wala or a sabzi wala, we should pay it through Paytm, which of course is now in a bit of a disrepute. But there are many other UPI-based transactions possible. When we can pay 10 rupees to a rickshaw wala through a digital UPI pay system, why can't political parties accept all their money through digital means? Why should we have this 2,000 rupees cash, 2,500 rupees cash? There should be zero cash. Every single payment to a political party and every single payment by a political party to anybody should be through digital means. If we could do that, since we are moving into the digital India and we are the world leaders in unified pay interfaces, we should do that and there'll be absolutely no black money at all.
Thank you so much. Anil, you want to add something to what the other two have said?
Yeah, most points have been covered, but what I would say, like Professor Chhokar said earlier, corruption is a larger issue. I mean, it affects various aspects of the society, but we are restricting ourselves to the political funding because I would say corruption is the fountainhead of all corruptions. If we are able to sort out this, I think it will have a effect on all the other things. So one of the things which a lot of people recommend is setting up of a fund. You may call it public fund, state fund, whatever. And there are various suggestions which people have given. One is that the election commission is made in charge of this fund and the government provides a certain amount of money based on the performance of the party and number of seats it's holding and all that and number of votes and multiplied by 100 and so forth. So there are various methods. I mean, of course, if you introduce that sort of a thing, then all the other electoral reforms, which we always talk about, which Shivani has also mentioned, they have to be done first. Because otherwise, if you have state funding of elections and all the other aspects are not sorted out, then again they will indulge in these type of things. So basic thing is that the parties need cash, that is black money. And why do they need it? Because they spend more than 10 or 15 times of what the authorized limit is for the candidates. And like Shivani brought out, there is no limit on the expenditure which a political party can do. So that is the main reason. So they have to devise ways like digitization is, why don't they do it? If they say कि rallies में 10 रुपया देता है, 5 रुपया देता है, अरे भाई, tell them to give it on digital, this thing. Why can't you record it? But they don't want to do it. The will is not there.
And another,
Sorry, Shivani, go ahead.
I just want to say one thing, which is that the onus also falls on the authorities like Election Commission, like Income Tax Department. I'll just give you one simple example. If political parties, we know that on record that political parties don't submit their financial statements on time, or the statement that they submit are not entirely correct. So then there is a provision under Income Tax Act, Section 13A, which says that if you don't do it, then you will not get 100% tax exemption. So has Election Commission till date taken out that tax exemption of any single political party which has defaulted, which has not submitted their statements on time, or which has not furnished correct statements? Has Election Commission ever done that? When the laws which are already in place, if they can somehow if they can take action around those laws, I mean, something can be done about that. It can at least send a clear message to the political parties, but nobody does that. So, yeah.
I'm afraid we are about to run out of time, but I do have to say, I respectfully disagree with General Verma on what he said is state funding of elections or whatever through a national election fund. And my reasons are two, but before that, I am totally against calling it state funding of elections. Because in India we have a system कि जो सरकारी चीज है वो तो मुफ्त है. The bijli is muft, pani is muft and free, but money is spent on everything. The state does not manufacture money. State collects money from people. If we were to call it public funding of elections, I think people will have a better idea of whose money is going to be given to political parties and candidates. My problem with the public funding of elections are twofold. Number one, if public money is going to be given to political parties, will political parties be asked to stop accepting money from anybody else? I would be very surprised that political party will stop accepting money from other people. If that is not stopped and an effective means of monitoring that is not found, then it will be like throwing good money after bad money. We cannot tell a public law enforcement officer that we will increase your salary by 5 times, you please stop taking bribes. That ain't going to happen. The second problem is, if we have to do public funding of elections, we have to know how much to budget for. And to budget for, we need to know how much money was actually spent in the last elections. There is no reliable estimate of that. And the only people who know that are political parties and candidates, and they are not going to tell us that. Therefore, there are these two practical problems in public funding of elections.
Thank you. So I will raise one last issue because this is the visible part of the money, whether through electoral bonds or not. At least, even if they were not transparent, the political party had to say that we got so much money through electoral bonds, if not from whom. But behind the scenes, a lot more money is spent in elections. So some studies have recently pointed out that in 2019, more money was spent in the Indian elections than the US. But if you look at the official limits, 75 lakhs per Lok Sabha constituency, etc., and add up the numbers and the money got from political parties, it is a fraction of the estimated actual money, which means that lot of unaccounted money, maybe several fold higher than what is accounted for, it has been operating with and without electoral bonds. So do you have any thoughts on whether that is okay, that should simply be made transparent, and officially every member of parliament files an expenditure statement with the election commission saying how much he or she actually spent, and all of them claim that they are well below the official limit. So on the one hand, the official documents show that they are spending well below the official limit, but everybody knows that actual spending is several times more than that, and that is not passing through any of the records or financial statements of the political parties. It is all unaccounted for money. So what do we need to do about that? That is the real elephant in the room.
While the elephant in the room is complete lack of democracy in the functioning of political parties. Why a huge amount of money, and what you said is right, the total amount of money that we have been chasing for the last 23 years is not even 10% of the total expenditure that the political parties do. But we have been chasing it because this is the only figure available.
Correct.
The elephant in the room is, if political parties were to function in a democratic manner in their internal functioning, then this amount of expenditure will not be required. And therefore, there are two fundamental things which are wrong, which if corrected, perhaps will go a long way. One is introducing internal democracy in political parties by law, which, as Shivani said, the 170th report of the Law Commission of India in 1999 categorically recommended. And the other is financial transparency of political parties, which we have been trying, as we all know. In spite of the CIC judgment, the political parties have refused to accept it, and the Supreme Court has not heard that case at all ever since it was filed. So these are the two things that need to be done, which are extremely difficult. I am quite clear they are not going to happen in my lifetime, but they will certainly happen in Shivani's lifetime.
Thank you so much. So that was his last statement. Any last statement from Anil and Shivani, and then we'll close.
Well, we welcome the judgment of the Supreme Court as far as the electoral bonds scheme scrapping is concerned. And we can only urge the voters to be mindful of the way the political funding is being done and to be an informed voter and take this aspect of funding also into consideration apart from the background information which ADR generates on My Neta app. And they should encourage digitization of donations, the
Thank you so
corporates as
much.
well as.
Shivani?
You are muted.
It's just that every act done, voters need to realize that every act done in public way by the public functionaries need to be in the public domain, and we have every right to question every function of the government. We are not just voting machine once in 5 years. We have a responsibility way bigger than political parties, and that responsibility is to act as the watchdog of every government action. So we need to be aware of our responsibility in an electoral process. If we call it participatory democracy, let it be participatory in real sense.
Thank you so
Trilochan,
much.
can I add a word about what is likely to happen in the implementation of this judgment?
Why not?
There are a lot of reports in the media that Election Commission or the Income Tax Department have found an old law which prohibits disclosure of such details of individuals or companies. And therefore, the State Bank of India might seek more time from the Supreme Court or whatever. My response to all that is that the expression electoral bond came into existence in 2017. Before that, there was no mention of something called electoral bond anywhere in entire laws in the country. And anything that referred to electoral bonds post 2017 has been declared unconstitutional by the Supreme Court of India. So how can there be any law pre-2017 which says that anything to do with electoral bonds should not be made public? So this is a false argument that is being propagated by interested people. And we have to be prepared to deal with it as and when it comes up. If the government files for a review, the review will be done by the same bench in chambers. If in a rare case of an open court review, we will also present our view during the review. If the SBI goes to the Supreme Court for an extension of time on any such frivolous reason, we will also have to present our view in the court. And the implementation of judgment is extremely crucial because the information that the SBI is required to give to the Election Commission and the Election Commission to make public will reveal a whole lot of things as to who has been paying what to political parties. And there is also information that a large number of companies which have paid these electoral bonds are shell companies set up by big companies. So it will give us a whole lot of information which will have to be worked on in quite some detail and taken to its logical conclusion. Thank you.
Thank you so much for all of you for your listening. So we will close here, and again on behalf of ADR, I hope the listeners liked it. We would request listeners, if there are certain issues that we have not been able to clarify to your satisfaction, please write to us, and we promise that we will respond to your questions if it is related to electoral bonds. So thank you, and goodbye for now. See the listeners again in the near future.
Thank you.
Thank you.